Being recorded.
Great, thank you. All right.
Should we start?
I just didn't see it. I apologize.
Okay.
But all right, starting alphabetically. Rod Axtell.
Here.
Beloga.
Present.
Ronald Barnes.
Present.
Jim Goodermont.
Here.
Kathy Gustafson. And we'll come back. Cynthia Hunt.
Here.
Ronna Lindell.
Here.
Tom Nelson.
Here, thank you.
Grant Peterson.
Present.
Steve Peterson.
Present.
John Stanley.
Here.
Jay Taylor.
Present.
Mark Thorson.
Present.
Carrie Weatherby.
Here.
And Roger Willett. So I show for the record, Roger Willett and Kathy Gustafson are absent at this point in time.
All right, with that, we'll move on to approval of the minutes for our last meeting. Those minutes, I understand there's a minor wording correction on those minutes, is that correct? And the minutes, by the way, are for the September 25th, 2019 meeting.
This is Ronald Barnes. I noticed that the approval sheet has September 23rd on. Last sentence.
Denise, did you have a correction to those minutes?
Actual date, Chair, was September, or I should say Wednesday, September 25th is a date that occurred on the calendar. Wednesday, September 23rd did not.
So, I'm sorry, there was someone that had mentioned that it is listed as September 23rd somewhere.
It's on the approval of the minutes on the back of the minutes itself.
Okay, I can make that correction. And then the other correction is to item 4.1, just changing one word from commissions to commissioners. So just a minor fix there.
With corrections or comments regarding? If I hear none, I'm looking for a motion of approval. Again, please state your name as you make a motion or a second for the record.
Jay Taylor to approve.
This is Ronna. I'll second that.
All right, we have a motion and a second. We will now do a roll call vote. Yea or nay, please.
Thank you. For the purposes of time, I will just go alphabetically with last names. Axtell.
Hey.
Beloga.
Aye.
Barnes.
Aye.
Goodermont.
Aye.
Hunt.
Aye.
Lindell.
Aye.
Nelson.
Yes.
Grant Peterson.
Aye.
Steve Peterson.
Aye.
Stanley.
Aye.
Aye.
Thorson.
Yes.
Weatherby.
Aye.
All right, sounds like that motion passed unanimously. We will, do we have any unfinished business? I don't.
I believe there is no unfinished business.
Okay. On to item 5.1, consider ordinance 2020-11 requesting voter approval to amend the charter related to solid waste collection. We have a staff report.
Right, Chair and members, this is Melissa Manderscheid, and I have a PowerPoint presentation that will guide us through our conversation tonight.
you.
So what you should be seeing now is a black screen that says Charter Commission meeting, May 7th, 2020. The materials from this presentation will be included in the final packet that is prepared by Denise after this meeting. And so it will be available for anybody who is interested in seeing it as well. I thought it would be helpful there, to discuss a little bit about the role of counsel, as in me, legal counsel. There were a couple of emails that I was able to read prior to this meeting where there were some questions about the role of the Charter Commission Counsel. So I thought I would take an opportunity to talk a little bit about that during our meeting tonight. When one is a lawyer, you have a duty of loyalty and a duty of giving legal advice to your client. When the client is an organization, that duty is a little different, and so that is the way it is when you are an attorney for the government. And so, in my role as legal counsel, my client is the city of Bloomington. It's kind of a hard concept to wrap your head around, but my duty is to the city as a government entity. I am not the counsel to the city council. I am not the counsel to the city manager. I am not their particular lawyer. My client is the city of Bloomington. So in that way, there are times when I have to deliver information that is awkward and uncomfortable to deliver, but I'm speaking because my client is the city. And I know that some of you all have experienced that when I have presented on previous charter amendments in the past, where I say, here are the positives of this amendment, and here are the negatives of this amendment. And so my duty is to present the full picture and to represent the city as an entity. This particular obligation is further described in our legal rules of professional conduct as well, where it describes the lawyer being employed by the entity, by the organization. And in this case, that includes and applies to the city of Bloomington and government agencies. There is specific language in state law about the need for or the ability to have counsel for a charter commission. I've included that language here. It does talk about the ability to set aside $1,500 to pay for counsel in service of the charter commission. The city's charter commission has a budget, and that budget is used for all of the various expenses that we have, paying for notices and publication, postage, and all those sorts of things. That item, that set aside, can also be used to pay outside counsel. The other thing to note is that if there is a desire to obtain or spend more than $1,500, that would require the approval of the city council. So I thought it would be helpful just to provide that as background and address what I observed as a couple of people having questions about that particular topic. It's a complicated area of the law, and we as government lawyers do our best to wrestle with that, and it can be particularly complicated. So I'm sure you all have observed when sometimes in meetings the council members will get frustrated by something, or the city manager will get frustrated, but I have to deliver the law, and I have to represent the interests of the city of Bloomington as an organization. So with that, I will get started with the specifics for item 5.1. So 5.1 is an action item before you tonight, specifically to consider City Council Ordinance 2020-11, which is an ordinance requesting voter approval to amend the charter as related to solid waste collection. The process for amending the charter is set out in state law. There are a variety of different ways that the charter can be amended. under state law. And the one that is being used currently is one that we have not used in the past, in the more recent times. It's not a very common way of amending the charter, but it is certainly a way that is contemplated in state law. So I think it would be helpful to provide a little bit of background as to how we got to this particular ordinance 2020-11, because it has been a process over the last couple of years. And for those of you that are familiar with the Jennison lawsuits, that is a part of the beginning of the story. In 2016, there was a petition submitted to the city clerk, and the city clerk signed a certificate authenticating the sufficiency of that petition, specifically that it met the number of signatures and those sorts of petition requirements. However, although the petition was sufficient, the council at that time found that the content of what was being sought to be accomplished in that petition wasn't constitutional. And so they chose not to put that question on the ballot, or that charter amendment in the form of a question on the ballot. We had some litigation about that matter for a couple of years, and in February of 2020, the Supreme Court ruled that the charter amendment, the petition that was being sought back in 2016 was valid. And so as a result of that, we decided that it needed to go on the ballot. That would be on the November 1st, or excuse me, the November 2020 election. We internally have referred to this as question 1. Unlike some other organized collection cases recently, where the court gave very specific direction as to what was the expectation of the court as to next steps, in the Johnson case, the court did not do that. We concluded that the court, at a minimum, was requiring us to put the language of that petition on the ballot in the form of a question. So the question will be approved by resolution by the City Council at a later date in preparation for putting it on the ballot, but it'll be something along the lines of, should the city charter be amended to include the following language? And it will be the verbatim language from that petition. And that's why I started of it here. It's 2 sentences long and several lines. So just to get a sense, it starts with, unless first approved by the voters in a state general election, which is what's happening in November of 2020. So that question 1 is the requirement that the question of having organized collection be put to the voters. Should the voters be allowed to vote on whether we have organized collection? And so it is sort of the threshold first question. And the second question is the actual charter amendment that you see described in Ordinance 2020-11, the one that you'll have before you tonight. And that is the question of, that is the charter amendment of, should the city be allowed to contract for organized collection? The actual question, should we have organized collection in the city? So that first question is the ability to, the right of the citizens to vote on organized collection as a part of the process of organizing collection. And tonight is the question, the sort of baseline question of, should the council be allowed to enter into a contract for organized collection? So it's complicated, but what I need you to understand tonight is that we are only taking action on question 2, on the amendment related to question 2. The amendment related to question 1 is already in process and will be framed up, and no action will be required on that until we set the actual ballot language. So as I mentioned, this is a statutory process. It's subdivision 5 of the statute that we've used in the past several times. And as I mentioned earlier, the council adopted that ordinance that's in your packet back in April of 2020. And then it did it in a public hearing. And now tonight, we're having a public hearing before the Charter Commission on that ordinance. What the statute provides is the Charter Commission has the ability to reject the language of that ordinance that the City Council adopted. It can accept that language, or it can provide substitute language. And state law gives the Charter Commission 60 days to consider that. And if during that 60 days, the Charter can ask for up to 90 days. The Charter Commission on ordinance number 20-11, either tonight or at some point in the future. If the Charter Commission accepts that language in the ordinance, the next step will be that the City Council will set the ballot language. This ballot language needs to be sent to the county in August of this year in order for the ballots to be prepared in time for the election. We have voting that occurs early on, well before November, and so that language needs to go to the county in August. If in the alternative, if the Charter Commission rejects the language then that the council has adopted, then the Charter Commission can provide some substitute amendment, and I would present that to the City Council for its consideration. And so to note that there is the actual amending of the charter, the language that's in the ordinance that you're looking at, and the language that was in the Jennison decision from form the actual text language will be in the charter, the actual language that will be inputted into the charter potentially. And then you have the ballot question. The ballot questions haven't been written yet because we don't know what these, on the second question anyway, we don't know what that charter amendment is actually going to say, so it's not possible to draft that ballot language yet. With regard to that first question, we have a general sense of what that question will be like because we have the language from the decision in the Jennison case back in February. I haven't committed it to a formal resolution for City Council consideration yet, but I suspect it will be something along the lines of, should the city charter be amended to add, and then it would include that verbatim language from the petition back in 2016 that was deemed sufficient. And it would be a yes/no vote like we have had on our previous charter amendment ballot questions. And then that second question, again, as a reminder, is what we'll be talking about. The underlying charter amendment language is what we'll be talking about tonight. Once that charter amendment language is set, either through the process you all have tonight, or if you decide to continue discussing it at a later meeting in July or June, once we have committed that language and it has been adopted by the City Council and the Charter Commission, then we will be able to prepare ballot language a ballot language that will form that second question that will ultimately end up on the ballot. So for consideration, we held a hearing. There was public comment that was received in advance, and it was provided to you by email, I believe, from the recording secretary. And then we will have the opportunity for people to participate in a live public comment process. And the directions for how to do that were provided in the agenda packet as well as online on the city's website through its typical notice information. It was also published in the newspaper. At the close of the public hearing, we'll ask the Charter Commission to consider those options that we discussed. Either accept the amendment as proposed by the City Council in that ordinance or reject it and provide some substitute language. If the Commission decides to have a discussion about substitute language, I would bring back that substitute language most likely on June 11th of 2020 at a subsequent Charter Commission meeting. I would collect the content that you would like me to put into a substitute charter amendment, and then I would bring it back to you for formal consideration at a subsequent meeting, which would most likely occur on June 11th. As I mentioned before, you have 60 days to review that ordinance that the City Council sent you, and you can take up to 90 days. And then there is the rest of the process. So I know that's a lot of content and a lot of process that we haven't used in the past. So at this point, I will stand for I believe all of your lines were muted during the presentation. So if the host could unmute the lines, then we will be able to know if people have questions.
Melissa, this is Beloga. So the first question is not before the Charter Commission because of the petition. Is that correct?
Chair and members, that is correct. The first question has already been, the first charter amendment has already been, the language of that, the text of that has already been deemed sufficient. And the only thing left to complete for that particular proposed charter amendment is to put it in the form of a question and put it on the ballot for people to vote on in November. The only item that we're looking at tonight is that other ordinance that was in the packet.
A follow-up question is, and it regards why there are two questions. And the rationale for asking that is if a majority of voters approve pass the first question in the favor of organized collection, why then is it not sufficient to end there rather than ask the second question?
Chair and members, or excuse me, Chair and Commissioners, it is, in our opinion, a second question is required because the first question that was proposed by Petitioners.
Melissa, you kind of fade out when you turn
I'm
your
sorry.
head.
I'll pull the mic right next to my mouth. Sorry about that.
Thank you.
Much better, thank you.
Okay, sorry about that. And I'm actually thinking that maybe I'll try and find that language so we all have it in front of us as well. The language of that petition that the court considered is asking for the ability to amend the process by which organized collection can occur by injecting a vote of the public into that process. It's a procedural amendment to the charter that, if you'll recall, the Jennison case was about a lot of things, but one of it was, could the process to transition to organized collection, could that change from what was stated in state law? And that is the content of that first question. Can the process be amended to require a vote by the public? So we have concluded that the threshold procedural question to organize collection. And the voters then would decide. And then that second question that the chart amendment you all are thinking about tonight is the fundamental question of, should the city have organized collection? So the first question is, should the process have a vote? And then the second question being, should the city have organized collection?
And the reason, Melissa, I asked that question is that if the first question succeeds, then all the ordinances and amendments to the charter stay intact. Am I correct in that?
Chair and members, Commissioner Beloga, in part, one of the things that the court wrestled with a lot in that Jennison opinion, in those Jennison opinions, was the two-sentence nature of that charter amendment, and that the first part of the amendment is calling for a vote of the public. And then the second sentence talks about a rollback, a sort of a a deletion of all of the ordinances and code amendments and anything that would conflict. So it would act to roll back and revoke all of the code amendments that have been adopted by the city council during a certain time period. And so if that first question passes on the ballot in November, then we will need to have replacement language in place should the outcome of the second question be to keep organized collection. So I'm not going to pretend that this isn't complicated. It's very complicated. And part of that complication is the fact that there are two questions, but also part of the complication is that that first question has two very distinct elements to it. One being process and the other one being a rollback of the regulations that have been adopted to implement organized collection.
Okay.
Commissioner Beloga, any further questions?
Well, what would the consequences be if there wasn't a second question? If the first question passes to continue organized collection, then all of the ordinances continue to exist as they are today. And doesn't that then supersede the need for a second question?
Chair and commissioners, I believe, although I don't have the ballot questions drafted yet, I believe it would be if the first question fails, then nothing else would be needed. Because if the first question passes, then the charter will be amended to include the language in that petition about the election and about the rollback of all of the charter amendments, or excuse me, all of the code amendments that have been adopted to date. So if that first question passes, we will still, or excuse me, fails, then everything would stay as is.
So no matter what the outcome of the second question, if the first question, I got confused on which way it goes, but the voters reject organized collection in the first question, then no matter what happens on question 2, it still is, the city is not able to do organized collection. Is that a correct understanding?
Chair and commissioners, it's difficult to answer that question because I don't have the language of the ballot questions in front of me because they haven't been drafted yet. But what I think Commissioner Beloga is getting at is that the language of the charter amendment that's before you tonight is drafted in the negative.
Right.
And so if you'd like, I can talk a little bit about that. So the way that and I'm seeing people like they want me to talk about it, so I'm going to keep doing that.
I would like you to do that.
Yes,
Okay.
I would
Thank you.
agree.
All right. So the council adopted on April 20th, Ordinance 2020-11, and that is a possible charter amendment to Chapter 12 of the city charter. And it states that the council shall not enter into a contract for residential solid waste. So this is drafted in the negative on purpose. I made a choice to do that. I could have drafted in the positive to say the council has the right to enter into a contract for residential solid waste. I made a choice not to draft that way, in large part because the city already has the right to do that. Under state law, there is a process that allows the city to do that. And so it seemed to me unnecessarily duplicative to amend the charter to state that when we already have the right to do that. It also seemed to me that there was a desire by the litigation to have a process whereby the city would have to overcome its right to enter into organized collection by contract. And so I felt that it needed to be drafted this way. And so I don't know what the ballot question is going to be at this point because I don't know what the charter amendment ultimately will end up being. But it was an intentional choice, and it was debated at length in our legal department about the legal, what made the most sense from a legal standpoint in how to draft this question. Now, this charter amendment, the actual ballot question won't say exactly what this charter amendment says because it's very long, and it will be something much more simple. If you remember back when we were working on the intoxicating liquor amendment last year that was on the ballot, we drafted language that we paid very close attention to trying to make it very easy to understand, and we tried to choose very simple and straightforward language. And so we will endeavor to do the same thing when we get to that stage, if and when we get to that stage. But to Commissioner Beloga and Chair and members' question about why it is drafted in the negative, I want to just assure you that that was intentional in a choice that we made in order to try and be clear about what the power or lack of power was in the charter.
Thank you, Melissa. Commissioner Weatherby, or Commissioner Beloga, do you have a follow-up?
I think we got into the language question. And my question to the attorney is depending upon whether or not the first question passes or fails, if it fails, then organized collections still exist. If it passes, that passage is not overruled by the passage of the second question, does it?
The first question.
What I'm asking is are the two absolutely independent of one another?
Chair and commissioners, when we get to the point of drafting that ballot language.
We're losing you again, Melissa.
When we get to the point of drafting that ballot language, we will endeavor to make it clear to the voters and of what that yes/no vote means. Similarly, we will explain in as much detail as we can in the ballot educational materials what I'm thinking will be in that ballot education materials will be the language. If you vote yes, you are voting to keep organized collection. If you vote no, you are voting to end organized collection. And then on question 2, if you vote yes, you are voting, that sort of thing, so that people will understand what is the outcome of a yes or no vote, even if the language of the actual question is long. On that first question, it's going to be long. So I think it'll be important for people to understand in very straightforward, simple ballot, voter education materials, what the impact is of a yes or of a no vote. Similarly, members, I'll offer that I have been working with our communications department to save space on the briefing in the issues of the briefing, as well as we have a webpage on the city website that will have all of this information on it as well. And I'm confident that we'll be working with the newspaper, the Sun Current, to get information in there as well. So we will do everything we can to make it clear to voters what they are voting on and the impact of a yes and an impact of a no in very straightforward, simple language.
Commissioner Weatherby.
This is a lot for my understanding of this. Why is this a charter amendment? It seems like a very specific kind of thing that's happening in the city that I don't understand why it has to be made part of the charter. I guess that's my question. Why is it in the charter? It just seems like it's just not broad enough to be included in the charter.
Mayor, Chair and members, we talked about that as well internally in preparing the research on this matter. And there are only certain ways. Well, let me back up and say the very first question that is on the ballot because that is the method that was selected by the petitioners in that process. So that one will be on the ballot. The need for that second question to be on the ballot, there are only certain ways you can get something on the ballot. A levy increase for the school district. You want to amend your liquor code, your liquor language in your charter. There are very limited ways that you can get a question on the ballot. And so in order to execute the steps necessary to get resolution on this matter and bring this question to the voters, the vehicle for doing that is to amend the charter. So while I agree that this language about the city council entering into a contract for haulers or with the haulers is currently in our city code, the only way to get it to the voters is to amend the charter.
And so that is a valid vehicle. It seems like our charter could get pretty muddied up with all these little specific things going on if we keep amending the charter every time somebody's disappointed with what's happening in the city.
Chair and members, I agree with you that the charter could have additional amendments if there are additional petitions and efforts to amend it this way. I will say that in drafting the language of this charter amendment before you tonight, Ordinance 2020-11, I kept that in mind and I tried to draft it in such a way as to be consistent with the high level that we have taken, the sort of constitutional approach that we have taken in how we think about our city charter. So again, one of the reasons that the language is at the level that it is and why our ballot question will not include the same type of language. It will be much more simplistic and understandable for many audiences. You know, when you're drafting language in a constitution like our city charter is, you have to be very precise in the selection of your language. And although we're precise when we draft our ballot question too, we have other things that we need to be mindful about. And one of those is clarity and understandability. So we run it through filters, our ballot questions through filters, and we work to get it to a 12th grade level in order, in an effort to make it understandable to the most number of voters.
It's not something that the charter commissions could say, this is not appropriate for our charter. It is legally valid to amend our charter this way.
Chair and members, it's legally valid to amend your charter using this process that's provided in state law. And with regard to the approach that we're recommending tonight, that is my legal recommendation, that in order to meet what we believe the court held in the Jennison decision, we need to do this, this approach.
Okay, thank you.
I'll also add that we contemplated putting some of these questions on an earlier, a vote or having a special election or something like that. But as you know, the turnout for those, earlier elections in the process are low, and historically low. And so having it on the November ballot gives us the opportunity to put this question in front of the number of voters and has the greatest opportunity for wide participation within the community. And so that was a choice and that we factored in on so that we could get it out to as many voters as possible. Especially given all that we have now transpired since then, I think that was an even stronger choice, and that we want the time to get this in front of everybody, and having it on the November ballot will allow us the time to do that.
Thank you.
Thank you. Commissioners Weatherby and Beloga, if you could uncheck your hands, your raising of your hands, and then you can recheck them if you have additional questions. That kind of helps me to see who I haven't called on yet. Commissioner Barnes, do you have a question?
Yes, for the attorney, how would you characterize the gist of the second question or the second resolution? What is it going to accomplish?
The second question will be the up or down vote of whether the council can enter into a contract for organized collection. Can the a contract for organized collection?
So if the first question at the election is to accept that amendment that says voter approval has to go and so forth. And if the second question is then also approved, well, where are we?
If the first question is approved, that's saying yes, the voter should be allowed to weigh in on this. And if the second question is approved, again, I don't know what that question is going to be, but if it's the language before you tonight, then the outcome would be that the council would not be allowed to enter into a contract for organized collection.
I see.
Commissioner Stanley.
I don't know where to begin. Let me just say I'm in favor. I'm glad you put in the language related to a state election. That's absolutely a good idea. I'm still confused by the 2-question issue and the possibility of them conflicting, as I think Councilmember Beloga, what you were getting at is you have a vote result for one question that conflicts with the vote result of the other question. But Attorney Manderscheid, it sounds like you're assuring us that you'll draft or the language will be drafted in such a way, or you will ensure that the language is such that that can't happen, that we can't have 2 conflicting results. Is that correct?
Chair and commissioners, that has been thoroughly discussed, and we believe that we have a plan to ensure that that is an understood part of the process when people are casting their votes. I'll also add that these are the types of questions that have to be approved by, in the affirmative, 51% of the voters. And so if a person doesn't vote on it, if they leave it blank, it doesn't get calculated into the math of the approval. And so that's an additional consideration that we have before us, and that the questions, we have to be mindful that an affirmative vote, a yes vote, a 51% yes vote will result in approval of that ballot question. So it's also factored into how we drafted the questions, rather the amendments.
clarification, we have 5,000 people that vote, but only 1,000 people vote on the amendments. And we only need 501 of that 1,000 to approve the amendments, even though there's 5,000 people voting in the election, just to pick numbers. Is that what you're saying?
Correct. Chair and members, a charter amendment vote is different than a constitutional amendment of the state constitution. The law is different on that. And if you remember back from the recent, more recent state constitution amendments, there was a lot of language about, the implications of a yes or a no or a non-vote. That does not apply to a city ballot question. The law is different.
Well, I think you just, I'm sorry, I think you just supported what I was getting at. My follow-up to that would be then, if this whole thing doesn't get to the ballot in a crystal clear fashion, and we run the risk of a large number of voters not voting on this issue, then we are at risk of a very small group of people determining the outcome of the issue. Whereas I think we would all agree we would like as many people as possible voting on this particular issue, since this is what all of this has gotten us to.
Members, that analysis is correct. If people don't vote on it, they choose to skip the questions, they will not be factored into the math on whether it passes or fails.
I have concerns, as I will tell you, while I am in favor of, I don't think there's anything wrong with saying that at this point, at least, I am in favor of the current system. I am nonetheless supportive of the argument that given our current situation with respect to meetings and irrespective of what we're doing all tonight, I am supportive of the concerns that have been expressed by, in just a few, admittedly, just a very few emails that we've gotten. This presents some transparency concerns for apparently some people, and it does therefore for me too, regardless of my own feelings on the issue.
Sure.
I say that just in so that as we get into this, I am supportive of taking a slower pace for additional meetings. And I guess that's all. I'll close it off there.
Chair
Thank
and
you,
members.
Commissioners.
Sorry, Chair.
Go ahead, Melissa.
Chair and members, I too am concerned about, or share your concerns about undertaking these important decisions during our current global pandemic. I share those concerns. I think that we have no choice but to put that question 1 on a ballot. We need to do that. We made the choice earlier in the process. The decision came down in February. We met with the council shortly thereafter, and we started that process. We're now in April, or the council adopted an ordinance in April. We noticed the language in the beginning of April. So we acted as quickly as we could after that February decision in order to understand it, try and figure out what the court wanted us to do, and then prepare those next steps. And in the intervening time, we had a global pandemic. And so in some ways, I'm glad that we made the choice to put it on the November ballot, and that it gives the voters additional time to understand what they're being asked to vote on. And it gives us additional time to educate the voters and get that information out to them in all the various ways that we can do that. So I too share your concerns about that. I think that we have the timeline that we have, and we don't have much play around the joints on tinkering with that first question. It's set. That first charter amendment is set. And so that will proceed forward. And with regard to the second charter amendment, if there is an inability to make a decision on that and get it on the ballot, that will create a lot of uncertainty in the city. And we wanted to put it on the same ballot question on purpose, or excuse me, on the same ballot on purpose, in order to get resolution on this as quickly as possible with the greatest voter turnout likelihood. And so that is in large part driving the recommendation and the timeline that's before you. I think that also add that when I was formulating the process for this, looking through state law, I added the I went the step further to make sure that there was a public hearing at the Charter Commission tonight, creating that additional opportunity. And we've sought as many opportunities as we can to collect people's information, and we continue to collect their comments and would continue to forward it to the Charter Commission and the City Council. We'll have, in as much as the global pandemic allows, we'll have information, learning opportunities about this, opportunities to ask questions. I don't know what format it's all going to take. A lot of it is driven by our public health authority and what's safe to do. But I can promise you that we're committed at the staff level to getting the information out there in as many languages and as many times and methods as possible, because this is really important to a lot of people, including the staff.
Commissioner Peterson, you have your hand raised.
Thank you, Mr. Chair. I think conceptually I'm in support of the proposed second charter amendment proposal. And the reason is that I think it allows for kind of every combination of voter intent to be recorded and us to come to a definitive conclusion at the end of the election cycle this year as to whether organized trash collection is going to continue or not in the city, and get kind of a definitive and final answer from voters on that particular question. And so kind of my general feeling on this is I would like to see it go ahead, because otherwise, if we don't have a question like this on the ballot this year, there are some outcomes that voters may want that we won't be allowing them to select from. And I think that would be a travesty if we did that.
Thank you. Commissioner Nelson, you have your hand up.
Can you hear me now?
I can hear you.
Oh, good. Thank you very much. So I have just a little question and then a broader question. So I'm looking at question number 1, and there are 2 questions I have about it. One is the language in it in the very beginning says the majority of voters. And Counsel, you may have already clarified this, but I take it that means, well, let me ask the question. Does that mean the majority of voters who could vote, or the majority of voters who vote?
Chair and members, or Chair and Commissioners, the law on how you calculate ballot questions is that 51% have to vote in the affirmative. So they have to vote yes. 51% have to vote yes in order for the ballot question to pass.
My question is 51% of what? If it's the total number of people who could vote, whether or not they vote, that's one thing. If it's the 51% of the people who vote, that's another thing.
51% of the people that that cast a vote on that ballot question. So if you leave the question blank and don't circle in bubble yes or bubble no, then it's as if it doesn't factor into the math.
Okay, so that would be my understanding too, but that might lead your ballot or voter education work to lead to a clarification, because the phrase majority of voters doesn't quite say that clearly. second question on the language is, I see 3 or 4 lines down, it says government design districts. Does that really mean government designated districts? Or is designed what the language was?
Chair and members, what Commissioner Nelson is speaking about right now is the language from the Jennison court case, the language of the petition. And we didn't select that language. The city didn't select that language. That language selected by the petitioners. I having participated in the litigation for the last couple of years since I joined the city, I think that we've been debating in the courts what it means and the intent of it. And so I'm not inclined to synthesize it in any way. I am recommending and will recommend to the city council later this summer that it state the exact language of that petition in the ballot question.
Thank you, Counsel. I agree with that. My only question is whether that's a typo, whether designed really is designated. But your answer is that designed is the language that is in the petition.
I can, chair members, I can double check that. I don't have it right in front of me, and I'm a little bit limited in because I'm sharing my screen through this WebEx on the kind of sorting that I can do.
And I think you answered the next question already, but I take it that what we're doing is we're setting it up so that both questions will be on the same ballot in the November election. Question 1, answer this. Question 2, answer this.
It is correct.
Okay, and then the third question is a little broader, and I appreciate your efforts on drafting and the way you and your team have approached it. In terms of helping me think this through, why would a member of the Charter Commission reject the language approved by the council?
Chair and commissioners, I don't know that that's a legal question. I will tell you that sometimes there are differences of opinion about approaches. We've had meetings where I think that the intoxicating liquor one is a good example where the council and the Charter Commission had a lot of discussion about what that ballot question would say. And so there are differences in opinions about how that drafting should be. I, as a bit of foreshadowing, I think that if there is an inability for the commission and the city council to come to an agreement about what that charter amendment is, I will recommend a concurrent session of the two bodies, because I think it's very important for public policy reasons and for clarity that the two bodies have a shared consensus and understanding about what that amendment is going to be. It's too important. It's too important, in my opinion, to spend a lot of time in a ping pong match, shifting back and forth. We need to come to a consensus and represent the views of, or take a position on behalf of the citizens and on behalf of the public in the city of Bloomington. So
yeah, thank you. So, and I agree. I'm not sure it's a legal question, and I appreciate that. But I take it in your efforts at drafting and at the council's, in connection with the council's efforts at drafting, you and they worked your best to create language in the charter amendment that would reflect the petition if the petition language was passed in question 1, correct?
Chair and members, we drafted it in part because of that, but not in total because of that. I set it up again, as I mentioned before, as a prohibition, as a thou shall not be able to do this, because that felt more consistent with the I don't want to say impetus or litigation, but it seemed like that the petitioners were looking for an up or down vote on this. They were looking for, and again, I wasn't there at the time. I'm just basing this on what I read and my experiences It seemed to me that that felt most true to the litigation. I will also say that what I mentioned earlier, in that I don't typically see charter amendments that, or excuse me, charter language that simply reiterates what's already in state law. The charter is meant to distinguish the unique nature of how we want the city of Bloomington to be. So to simply say what the state law already allows us to do doesn't seem to be necessary. Doesn't seem to be an added value to the charter or in any way distinguish it from what we already can do. I thought it would be more clear. And then lastly, I thought it would be a more clear outcome. So,
and thank you for that. Yeah, thank you for that. It seems to me that the way that ends up being communicated to the public is that what we are saying in question 1 and question 2 is, if you vote yes on question 1, then here is the language that we think faithfully implements the underlying policy and goal of your answer to question 1. So that your drafting and the council's position, I take it, are meant to be implementing and coordinating with each other.
Chair and members, I can't read into the minds of the city council when they acted on this matter. There was a great deal of discussion, but I will tell you that it was a technical and a legal decision to draft it the way that we did. We spent a great deal of time discussing it and landed on the approach that's before you tonight.
Thanks very much, and thank you for your patience. Thanks, commissioners, for your patience with my questions.
Thank you, Commissioner Nelson. Commissioner Axtell. Commissioner Axtell?
This line is muted.
I will move on to Commissioner Stanley has another question, then we'll move back to Commissioner Axtell when our technical issue is corrected. Commissioner Stanley.
Thank you, Mr. Chair. Attorney Manderscheid, where are we at if we don't get this done in time for November's ballot?
Chair and members, state law provides only a certain amount of time for you to consider this. I included the language here in case we needed it. And if we run out of time, then if we aren't able to come to an agreement about what this charter amendment language is going to be, then we won't be able to set the form of the ballot question. But that first question will still be on the ballot. That first question that includes the language from the petition will still be on the ballot in November, assuming, of course, that the council acts on my recommendation to approve that ballot language.
And that full language is in our packet, or can you put that up?
Chair and members, I will get that language from the Jennison opinion. I'll go and grab that.
That's what I'm trying to, I'm just trying to get a better understanding of what the net result of the Jennison ruling, where that put us. Did it put us anywhere other than having to put this on the ballot, or did it put us somewhere beyond?
Chair and members, I will tell you that the Jennison opinion by the court did not provide us with a clear roadmap as to what we are to do next. It was unlike the other opinions that were handed down on organized collection for other in St. Paul, where they gave them a very clear directive. We didn't have that in ours, and so we are left to, as we sometimes have to with the court's opinions, we're left to figure out what the court wants us to do. And so we sought to do that in this case and spent the time we thought needed and necessary to reach that conclusion. And now are moving through the process that we've discussed tonight.
My point is, or my concern is that there's a certain tension here between getting this done in time. If we have to get this done by a certain, we have to get, if somebody forces us to get this on the ballot in November, if some part of this, versus the tension of not proceeding too quickly in our current environment. With respect to this question of transparency, which is, this is the big deal here in Bloomington these days, is that the City Hall doesn't tell anybody about anything. I don't agree with that, but that's a perception. And so there's this tension here between moving too fast versus moving too slowly. And I wanted to make sure what our exposure as a city is with respect to one or the other.
Members, I hear what you're saying. I think the impact of not taking action and getting this on the ballot on the second question on the ballot in November of 2020 is a long period of ambiguity as to what is the status of organized collection in Bloomington. It will take a long time for us to get organized, not in a, organized in a sort of technical sense as to what we're going to do, because we'll have that first question out there that rescinds all of our authority that was adopted in 2015 and 2016. I'm talking here about the second sentence of what will turn into the ballot question. That language essentially revokes all of the implementation language that we have in our city code about how trash is going to get picked up in the city.
If this, go ahead,
Commissioner Stanley.
Well, if this language, if this was the only amendment on the ballot, followed by, as you had alluded, you had earlier, making sure that whatever's on the ballot is going to be explained very clearly to everybody before election day. Is this, it just seems to me that this language is fairly clear, unless first approved by a majority of the voters. And the result is, if you vote yes, it's going to be this. If you vote no, it's going to be this. And if you vote at all, it's going to be this. If we had that kind of accompanying explanations with this single ballot question, that would get us to where we needed to get. And that is, if it's voted down, then we are able to, the city's able to continue to run its trash collection the way it wants. If it's voted in the if it's voted in favor, then the voters are saying, no, city, you can't do that. Wouldn't that be sufficient to get us where we need to get?
Chair and members, I appreciate that, and I think that that's a reasonable conclusion to arrive at. But from our analysis, we concluded ultimately that this two-step question or two-step process on the questions is required because it's not clear enough from that first question as to what is happening there. Because the Jennison lawsuits were about the process of organizing collection, about what could the process that's in state law be altered. And the litigation talked about that and a couple of other topics as well. But we believed, again, because the court did not provide us with specific next steps, we believe and are recommending this two-question process so that it's crystal clear what the voters are seeking to do. The ballot education, just as an aside, the ballot education material is not legal, right? It's just our effort to try and explain it. Some of the voters aren't going to see it because they won't, they they throw the briefing away, or they don't ever get on the city's website, or they don't open their mail, or, you know, whatever. So we wanted to we believe that it's the most consistent with the court's opinion and the most clear outcome to have this question 1 and question 2 process.
On to Commissioner Axtell, who has his hand up. Commissioner Axtell, are you there?
I am. Hopefully you can hear me.
We can hear you.
Yeah, it's my understanding that our goal here, our role here tonight is to simply approve an action that took place at the city council meeting on April 20th and to approve what they voted on, so so this can go to the November election, be on the ballot, consistent with the Supreme Court. Am I mistaken that? Please let me know.
Mayor and members, that is where we are at in the process. Correct.
So with that said, I certainly don't have any problem at all with the current language, and this is something that I think is best for us to do and for the city to accommodate the voters' desires.
Thank you, Commissioner Axtell. Commissioner Beloga, you have your hand up.
Thank you. So here we are a year from now when we're reading the city charter, and it says, "Thou shalt not enter into a contract for organized collection." Very simple, straightforward. But we have. I'm having a problem accepting the contradiction.
Members, I can address that. We worked through that same contradiction in that first question, and it was in part why we believe there needs to be a second question. Because if you look at the petition language that I'm sharing on my screen right now, it talks about how the city shall not replace the competitive marketplace with a system of organized collection, essentially. Since that's already happened, we had some concerns when discussing this, that this would be confusing for voters at this stage in the process, right? 4 years later, 4.5 years later. And that in part led to we believed the need to have this second question, which would make it crystal clear to people that they were voting yes, they want to keep organized collection, or no, they're done with organized collection. Because of the way that the language was stated in the past. Now, with regard to the contract, Commissioner Beloga, we have a contract in place right now with the haulers that's called the consortium, which is the group of haulers that pick up the trash. And that contract, by its terms, ends on December 21st of 2020. We are, as the council has authorized staff to do, we provided that final link. We have working towards that finalization of that language and have spent a great deal of time making sure that both the consortium and the city understands the termination language, because as a result of this election, potentially on these two questions, that contract could be rendered invalid. We would lose our authority to be in that contract if this question or this charter amendment becomes effective. So we very, very carefully and diligently drafted the termination clauses and amended the language to apply to the original agreement that's in place right now to address all of the various possibilities of the November 2020 election, and have engaged in a conversation to make it with a consortium to make it crystal clear what is happening, what is required of the law, what is happening as a result of the election, and what is the implication on the contract, both the new contract as well as the original contract. So we have endeavored to clarify and wrap all of that up. and to add, and because the ballot questions are not effective immediately, they're effective 30 days later. That is also a part of our conversations and analysis on how to terminate that contract. So I think you all can get the sense of how complicated all of this is. We're doing everything we can to make it crystal clear for all of the various parties that are involved as to what will be the implication of keeping organized collection, what will be the implication of not keeping organized collection for each of the various parties involved, not least of which being the individual residential households.
So 5.5 years into the future, when that contract terminates, will the council be able to enter into a new contract, knowing that the charter says they shall not enter into a contract?
Chair and commissioners, if the charter is amended to include the language that's in Ordinance 2020-11, because that ballot question passed in November of 2020, the city will lose its authority to have a contract for organized collection upon the effective date of that charter amendment in early December of 2020.
Commissioner Bloga, follow-up question?
Nope, I got it.
All right, Commissioner Barnes, you have your hand up.
Yes, Attorney Manderscheid, the same question, I guess, similarly as Jack was talking about. Why does the second question amend the charter to say the council shall not enter into a contract? Do we expect that to lose? I mean, will the explanation to voters be that if you want to continue the collection as it is, you would vote no for this? That's question number 2. I don't understand that.
Chair and members, my current thinking on this, and now again, I haven't drafted the ballot question, but I've clearly given it some thought because it's relevant, is that if this is the charter amendment that is ultimately before the voters for consideration, then the outcome of a no vote would be to keep organized collection.
Well, okay.
Thank you. Are there any further questions at this point? We will also have an opportunity prior to voting to ask additional questions, but at this point, are there any further questions of staff here? If not, I will open up the public hearing portion of the meeting to hear from citizens who have an interest in this item. I would ask that residents state their name and their address for the record, and to also keep their comments to 3 minutes or fewer. And with that, again, I'm opening up the public hearing portion.
Mr. Chair, this is Chris Wilson. I'm just going to reach out to our operator. Cindy, can you hear me? This is Chris with the city staff.
Yes. So if you would like to ask a question, you will need to press *1 on your telephone keypad.
Chair, just to be clear, the operator said if you would like to ask a question, because we are in public hearing mode, what actually we're seeking from those that would like to participate when they press *1 would be to testify at the public hearing that's now currently open.
Thank you. That's a good point.
We have
So
one
that's, I
question
believe,
on
people's expectation would be.
Go ahead, Cindy. Do we have a caller on the line that wishes to speak?
Yes, from the line of Jonathan. Your line is now open.
Hello, can you guys hear me?
We can hear you.
All right. My name is Joel Jennison. I'm actually the named person on this on the lawsuits that I've been going through. Anyhow, the going way back, and I never thought we'd be here 5 years later by any stretch of the imagination. And even when we're at the Supreme Court, I don't think the Supreme Court thought that we should be here in any stretch of the imagination, because one of the judges even asked that specific question: why are we here? Why hasn't this been put to the ballot? So anyhow, and wholly our intent was to just make sure the citizens were represented. The citizens had a voice in the process. And going through this and listening to the city attorney's comments, they seem very pointed towards the city, the city incorporated, and didn't take into account what citizens may or may not want. And I guess it is my belief that the Second Amendment is wholly unnecessary, as it creates a potential conflict even when, let's say, the First Amendment, which is our Citizen Amendment, let's say that were to fail, and then the Second Amendment passed. So that would say that organized, that the city doesn't have to go through the process, but then organized collection is the city can't enter into a contract for organized collection. So I don't know, it just seems like there's a lot of legal loopholes there. And I guess at a very minimum, I would encourage the Charter Commission to put this on hold. We were in litigation for 4 years. I would anticipate having a fresh outside counsel would provide a great benefit to understanding the scenario, to see what somebody else might think, instead of somebody who probably has a city incorporated bias, and somebody else who has a fresh look and a fresh interpretation of what the rulings from the Supreme Court had said. So, I mean, ultimately they said the city was wrong, the city acted illegally, and, why are we here? Put this on the ballot. So, the good thing is we got our question on the ballot, and now it seems we're in a position again where, the city is trying to do things so that they can still have their organized collection, have their cake and eat it too, which, great, fine. But, the first question answers whether or not there should be organized collection. The first question also allows the city to go down
Speaker,
the path.
you have 30 seconds left.
Okay. The first question also still allows the city to go down the path of choosing an alternative system. If they want to make it a municipal system, there's nothing about that that stops it. It just says that citizens should be involved in that discussion, and be in line to have an approval phase to it. That's all it says. And to have a Second Amendment, it just confuses the ballot. And like I said, I guess at a minimum, I would encourage you to seek outside counsel, because this has been in courts for a long time. It doesn't need to be in courts any longer. So
Thank you for your comments. Thank you. Appreciate it.
thank you.
Next speaker, please.
Again,
Yeah,
to
but
ask
any
a
other callers?
question, you will need to press *1 on your telephone keypad. As of the moment, we don't have any participants on the queue.
Mr. Chair, this is Chris Wilson. If I might, I just want to clarify for anyone listening on the call. To speak under this public hearing, you need to call in to the following phone number: 1-866-873-0999. Again, the number to call if you wish to provide public comment is 1-866-873-0999. 873-0999. And the conference ID, once you call that number, is 547-8948. Again, that's 547-8948.
Thank you.
While we're waiting for any additional callers to potentially call in, I wanted to just make a clarification. I had a typo on those resolutions that are before you for possible consideration tonight, and I had the date of 2019. I should have written 2020, and I've made that fix in the execution copies. It's at the very top of the document. I just didn't catch it. Everything else is 2020, but my apologies for that error.
Thank you. Chris, how long would, I know that you've got a bit more experience with these, how long would you typically wait to see if anybody else has called in?
I would think we would check back with our operator, Cindy, in just maybe 4 or 5 minutes to see if anyone else has called in. So you might see if commissioners have any additional questions. I see Commissioner Beloga and Commissioner Goodermont with their hand raised in the WebEx software.
Commissioner Goodermont. Commissioner Goodermont?
Yes, okay.
You have a question?
Well, my concerns are that it's the 1 and 2 part vote is a little confusing, and I think a lot of people will not vote. They'll just skip over that. And I would like to see a little bit simpler question, maybe just a single yes or no vote. I mean, if people want it, the citizens want it or don't want it. It's maybe that's too simple, but it's gotten very, very complicated and very confusing, and I don't understand some of this. I'm not a lawyer. That's my comment. Thank you.
And some of that rationale for the 2 questions has been discussed here. Commissioner Barnes.
Attorney Manderscheid, it would be correct that the expectation for the explanation of how to vote is going to be 2 negatives, and you, in order to preserve the system that we now have. First, we reject question 1, and then we reject question 2. Is that not correct?
Chair and commissioners, again, I haven't drafted the questions, but I think hypothetically that an outcome would be that if you voted no for both question 1 and question 2, that neither of those amendments would go into the charter and the system would stay as is, organized.
Do you feel then that a subsequent charter amendment would be necessary or appropriate that specifically says that we can do collections collective?
Chair and commissioners, I do not recommend and don't believe that a subsequent charter amendment is necessary, in that the state law already gives us the authority and we've already gone through that process to organize. So I do not believe that a subsequent charter amendment formalizing our authority to do that in state law would be necessary.
Thank you.
Commissioner Stanley, you have your hand up.
Switching, yeah, I'm sorry, I had to unmute. Attorney Manderscheid, switching from the issue or the question of how the public votes come election time to how we need to vote tonight. Can we be clear? Can you please clarify what the result of a yes or no vote on this, where that leaves us as a commission?
Sure. Before you tonight, Chair and Commissioners, is are different options. One is to approve, to adopt a resolution approving the proposed amendment that the City Council adopted back in April, or you can adopt a resolution that rejects their proposed ordinance language to amend the charter. And then if you reject it, I would recommend that you begin a discussion of what you would like to see as a substitute charter amendment, and give me some direction as to how you want me to draft a subsequent amendment so that we can continue forward in that process and bring some language for your action on June 11th.
Commissioner Stanley, does that answer your question?
Well, to the extent that I understand all of this, which is not 100%, I guess in all fairness to Attorney Manderscheid, yes, I think that answers my question.
Thank you. Commissioner Nelson, I see your hand up.
I think Commissioner Weatherby was before me.
I'm not saying that. Who do we have before? Oh, Commissioner Weatherby?
I think she had her hand up
Yes.
before. Yeah.
Yes. My question is, do we have to have the public voting on the charter commission, the charter language? Is that how we've always, I'm just not recalling, is that how we've done all of our amendments to the charter in the past? Or can we just have the public vote on the first question and then we place the language in the charter without voting on it?
And members, there are various different ways to amend the petition, 4 of them. And the approach that's taken here in the language on the screen is one of those approaches. It's the petition that results in a vote on the ballot. And it is our opinion that, or it is my opinion, that this ballot or this petition here requires a subsequent vote at a state general election. And that's why we're using this process that we are tonight, and that we've put in place in order to put the question of amending the charter on a ballot question.
But do we have to have the voters vote on the language? I think it might be much clearer to the voters if we just have that first question on the ballot. And then the question as far as what the actual language is going to read, we could do within the commission.
So Chair and Commissioners, what we believe this petition language is saying is that you must go to the voters and ask whether you want organized collection. And so that's why
we're doing that with question 1. Aren't we doing that with question 1? We're putting it to the voters as to whether we want it or not.
Chair and Commissioners, I believe that is one interpretation, and that it's the interpretation of the person who testified in the public hearing. When we analyzed the court's opinion and analyzed the process, the language, we believe that it was most clear to have a second question on that election, the state general election. We believe that that's what the petition language is requiring of us to do.
So if we as a commission vote that down, or we're doing something illegal? I mean, can we vote to have just the first question on the ballot and not the wording on the ballot? Or is that illegal for us to do that?
And Commissioners, the Charter Commission could reject the charter amendment. If it is the will of the body tonight to not have that second question, the body could reject the amendment, and then I would report to the City Council that that was the outcome of the Charter Commission, and we would endeavor to figure out a path forward. At this point, I don't know what that path would be.
Well, we could approve language later, right? I mean, if they voted to stop organized collection, then, like you said, their contracts become invalid, and then they have to proceed on with not organized collection. And then as far as amending the charter and getting the proper language in there, we could do that at a later date.
Chair and commissioners, that's partially accurate with regard to the first sentence, but with regard to the second sentence, there will be no regulations in place to have the collection of solid waste, because this particular question sends all of those actions.
But the question is, do we have to have the public vote on the language? I guess that's where I'm confused. I don't understand why the public has to vote on how we're going to amend the charter to reflect their feelings in question 1.
Chair and commissioners, we have to put it on the ballot because the petition that was submitted back in 2016 put that process in motion. So we have to put it on the ballot.
Okay. The language part of it. The language part. Question 2.
The language part, question 2, I'm not sure I understand.
Well, that's question 2 is, are we going to amend the charter this way, right?
Both of the questions, both chair and commissioners, both questions amend the charter. So if question 1 is adopted, the outcome of question 1 is yes, and the question would be something along the lines of, should the charter be amended to add, unless first approved by a majority of the voters in a state general election, the city shall not replace the competitive market, the adoption of this charter amendment 2015, 2016, like that paragraph, that if that question passes on the ballot in November, then that language appear in our city charter.
Right. I'm just trying to make it less confusing for the voters. And if we just have one question, yes or no, and then we deal with the second question either in another, I don't understand why people have to vote on the exact language that's going in the, I mean, they're both, if we pass 1 and we don't pass 2, or no, what the caller said, if we pass 2 but we don't pass 1, then it's contradictory. So I don't understand why we can't just have one question.
Chair and commissioners, I agree that if the second question, if the outcome of the second question is different than the outcome of the first question, it's not a fatal result.
What would be the result then?
First question, the language in the amendment of the First Amendment question is saying you have to take it to the voters. And then that second question is taking it to the voters.
Mm-hmm. Right.
Okay, but that couldn't be combined into one question to make it more clear. Because obviously it's confusing since all of us are very confused about it and we're looking at it and discussing it. So I would like it to have it as simple as possible for the voters on the ballot.
Chair and commissioners, I fully agree with you that the language in the petition can be read in multiple ways, which is in part why it was litigated for years. And so I am not inclined to recommend that I come up with some sort of, and the city council adopt some sort of synthesis or short summary of what this petition to amend the charter is seeking to do in an effort to try and clarify it for the voters. I'm not inclined to do that. I fear subsequent litigation should I not summarize it in a way that the petitioners believe is an accurate reflection of what they sought as a charter amendment, given that we are on the heels of many years of litigation about what it meant.
I'm just afraid we might be in more litigation just because it's so confusing. But okay, that's my comments. I don't see that it's necessary, but It just adds more confusion to the voters and to the general public. I just don't understand it. I don't understand why we can't make it simpler.
All right, thank you, Commissioner Weatherby. We'll be getting back to this after the public hearing as well. Commissioner Nelson, you have your hand up.
Yes, thank you. So I'm trying to come up with November scenarios, assuming the proposed language, and it seems to me there's just one question I end up with, I think. If question 1 is answered yes, then you go to question 2, and if the answer is yes, then the deal's done, it seems to me. If question 1 is answered no, then there's no real reason to get to question 2 because it's over. But if question 1 is answered yes and question 2 is answered no, then I'm confused about what the result is, because I think I heard that wasn't that might be game over instead of let's try for substitute language.
In commissioners, I can answer that question. I just wonder if we want to maybe, well, I'll answer that question, and then I think we want to maybe go back and make sure that there isn't anybody waiting on the line to participate in the public hearing while we discuss this.
Pick the time. You can handle it whatever time you'd like. I thought there was nobody else on the phone.
I think that's actually a good point. Let's take it back and see if there's an item, then we can go ahead and have a motion to close the public hearing portion and get deeper into our discussions here.
In part, Chair, I'm trying to be responsible because we have to pay the operator who's managing the call. We pay that for that service, and so if the public hearing is over, then we'll be able to dismiss the operator and save the city some money.
Thank you.
Mr. Chair, this is Chris. I will check in with our operator. Cindy, are you there? Can you hear me, Cindy?
Yes, I'm here.
Do we have any new callers on the line?
Yes, we have. And if you would like to ask a question, you will need to press *1 on your telephone. Your first question comes from the line of Russell Bernison. Your line is now open.
Yes, this is Russell Bernison at 4716 9 Mile Creek Parkway in Bloomington. And I've been listening to this all night, and even though I'm very familiar with what's going on with these different charter amendments and probably been along these lines for several years, how in the world can we communicate to the public why there's two questions about the same thing? And like I just heard one of the commissioners say a little bit ago, if we pass item 1 in the affirmative, which puts organized collection out, and then we come back and vote no on option 2, organized collection is then gone, right? Is that the way you're trying to proceed it with 2 questions? Because people are coming to me and saying, what are we doing with 2 questions on the same thing on the same ballot?
Chair and Commissioners, or Chair, we don't typically respond to questions during public comment. We take public comment, but after we close the public comment, I think it's appropriate for me to talk about that in more detail if you'd like.
Well, that's just my thought. That's why the 2 questions. I know you've been discussing it all night, and that's just my input because I'm getting a lot of questions from a lot of people as to why there's 2 on there. I heard all the arguments, but I agree with that we should be able to just do it with 1 question, and rather than confuse the issue. That's my comment.
Chris, can you press the operator?
Yes. Thank you, caller. Operator, is there any additional callers on the line wishing to speak?
Yes, from the line of Randy Sutter. Your line is now open.
Thank you. Yeah, this is Randy Sutter at 5310 Paola Circle. One of the things that I haven't heard discussed tonight is the impact of getting on the November ballot if this question is tabled until June or even July. I know that the question and the language needs to be finalized by August, but I did not hear that there was an adverse impact of being able to wait until the public is actually able to see the language that was presented in the PowerPoint tonight, which I know I have not been able to see, and I have not been able to appreciate the complexity of the question or be able to respond to it without seeing the proposed language. I would think we would also want to see the proposed language for the first question to be able to see if there is in fact any final conflicts between the two. So I would urge the council to the commission to defer this question until after there's a chance for more public input and debate on the subject and more advice to the commission members. Thank you.
Thank you, caller. Cindy, do we have any additional callers on the line?
As of the moment, we don't have any callers.
Thank you. Mr. Chair, it would now be at your discretion to entertain a motion to close the public hearing if you so. Oops, Mr. Chair, you are muted. Mr. Chair?
I would now look for motion to close the public hearing portion of this item.
Moved by Commissioner
Move
Peterson.
that we close the public hearing portion of this meeting.
Second by Jay Taylor.
We have a motion and a second, and now we'll do a roll call vote on this item for closing the public hearing.
Thank you. Axtell?
Aye.
Beloga?
Aye.
Barnes?
Aye.
Wittermont?
Aye.
Gustafson? Gustafson?
Commissioner, can you hear us?
We'll come back to Kathy. She had arrived on the call a little bit late, but I was informed that she was on, so I'll come back to that. Hunt?
Aye.
Lindell?
Cindy, this is Matt.
Yes.
Nelson?
Yeah, Cindy, I just wanted to let you know that I'm going to disconnect from the call, but please leave it active until the host, Chris, lets you know that you can end the call.
Okay, sure.
Okay, thank you.
Okay. Nelson?
Aye.
Grant Peterson? Grant Peterson, are you there? We'll come back to Grant. Steve Peterson?
Aye.
Stanley?
Aye.
Taylor?
Aye.
Thorson?
Aye.
Weatherby?
Aye.
And then back to Kathy Gustafson?
Aye.
Thank you. And Grant Peterson?
Aye.
Thank you.
Thank you. Motion passes unanimously. It's now
Mr.
time
Chair?
for,
Beg your pardon, this is Chris Wilson. I'm just going to speak to our operator for a moment.
oh, sure.
Cindy, now that the public hearing has closed, you may end the call and disconnect your attendance at the meeting.
Thank you. Ladies
for
and
your help tonight.
gentlemen, you're welcome. This concludes today's conference call. Thank you, everyone. You may now disconnect.
And for the record, may I please clarification on who seconded the closure of the public hearing?
Jay Taylor.
And I think I had him for the motion, and there was a seconder.
Weatherby made the motion. Taylor made the second.
I'm sorry, who made the motion?
Weatherby.
Thank you.
All right, Commissioners, time for further discussion on this item. I see Jack, your hand is raised. Jack Beloga, Commissioner Beloga.
Thank you, Mr. Chair. Attorney Manderscheid, I understand what you're saying, but we've now heard from two of the litigants. And it strikes me that one of the things that they're telling us is that two questions can continue the litigation. Any response to that, or possibly do you disagree with my conclusions?
Chair and Commissioners, I'll think that we could have made a variety of different choices, which would have had the potential for inviting litigation. Not just.
Melissa, could you hold your?
We're having a hard time hearing you.
Sorry, folks. Chair and Commissioners, I think that we could have made a variety of potentially invited litigation from the Jennison litigants, as well as from people on the opposing side of the position of the Jennison litigants. We analyzed multiple, I believe there were maybe 10 different alternatives that we analyzed in thinking about move forward with what this opinion, this February 2020 opinion guided us to do. We believe that this is the most, albeit, I appreciate potentially complicated and difficult when we're only talking about the nuances and digging down into the deepest levels at this point of the conversation. But I don't think that when we get to November or September, when people start voting, that we will have the same amount of questions. I am confident that the path that we're and presenting for your consideration tonight is a thorough and conclusive decision on whether there would be organized collection in the city. If we had only the first question on the ballot, only this first language in the petition, I believe that that the result of that would be and by having the second question, we conclusively put forward a yes or a no on organized collection in the city. People can disagree about the approach and whether it's necessary, but if we didn't do it, if we didn't have that very clear yes or no on organized city, we run the risk of people putting forward challenges to what does it mean to vote yes on that first question? What does it mean to vote no? So that is why we're recommending that we're putting forward tonight. We're not the ballot. We're not approving ballot language tonight. We're talking about language that will appear in our city charter. That's what we're talking about. The ballot question is just the method that amends the city charter. It's the same thing as when the city council has to have a unanimous vote in order to amend the charter. It's just another method. It's the method, this question is the method that was teed up for us as a result of the Jennison decisions. Ballot questions are that result. But what's really happening here, if they pass, is that the charter will be amended to include the language in this petition and the language in this charter amendment that's before you for your consideration tonight.
I thank you, Attorney Manderscheid. I can understand and accept all of that. with the exception of what Commissioner Nelson had asked. And that was if both questions are up, a yay, or both questions are down. But then when you get to the split decision, how does that operate? And I think that's the question I've asked now for the third time. And I still am not understanding the answer.
Chair and Commissioners. Again, I don't have that ballot language in front of me, so I don't, it's challenging for me to both answer your question in a way that is fully explains the issue, but also because I don't know what that ballot language is going to be, because I don't know what the charter amendments are. But I can say hypothetically that if you answer yes to the first question, that question is saying, as I understand it, should the charter be amended to include this language? Voters get to vote on whether we have an organized collection, essentially. So if you vote yes to that, then the voters get to vote on whether to have organized collection. So then you proceed to question 2. And if the question 2 is, should the charter be amended to prohibit the council from contracting for organized collection or something along those lines, and you vote no to that, then that is your split vote. The first question is just saying, should the voters be allowed to vote on this? And then that second question is the act of voting on it. Organized collection. Does that clarify it at all? I hope it does anyway.
With your response, it would seem to me that what my feelings are at this moment is that the commission should direct you to should table the item, direct you to draft the ballot language, and then come back with that language at another session so that we could discuss and understand where it is that we think is the appropriate direction. One opinion.
Thank you. I apologize if I'm out of order, or if I did not notice the order in which people have raised their hands. So I will just move on to Commissioner Stanley. You have your hand up.
I would echo, thank you, Chairman Thorson. I would echo what Councilmember Beloga said, I think, and that is we could vote for or against the actual charter amendment language, but as long as it's still conflicted, as I believe we are, over possible conflict between the language and outcomes of voting for 2 different questions, when we have the second question, we could all vote and figure out the language, but if we still feel like there's going to be confusion getting to that point, I don't think we're going to accomplish much. And I guess I would second Councilmember Beloga's suggestion that we see actual sample second question, that's more important than whether we vote for or against the proposed charter amendment language. If that made any sense at all. That's all. Done.
Chair and members, I'm certainly willing to draft some hypothetical ballot language. If you're comfortable with me drafting it with the charter amendment language as is presented in the packet tonight. I think one of the callers suggested that the language wasn't provided to the presentation, which didn't reflect or wasn't made available to folks. Clarify that the PowerPoint materials, with the exception of the discussion about the role of counsel, legal counsel, those materials and the information was taken from the packet. And the only thing that the body is being asked to consider tonight are those text of the charter amendments. There's no ballot question before, that was somehow not included. So I just want to make that clarification. And then again, add for those folks that maybe didn't hear it at the very beginning, that the PowerPoint will be added to the packet, which will be available online as soon as the recording secretary is able to make that addition to the packet. So it will be available. I'm certainly willing to take a stab at some hypothetical ballot question language and then create a matrix of yes, what a yes no vote, what a yes vote means, what a no vote means, and offer that up as a point of clarification for folks. I'm certainly willing to do that, and we could have that ready for the June 11th Charter Commission meeting.
Thank you. Commissioner Barnes.
Attorney Manderscheid, if we did have a split vote where question one is approved, and as a result the charter is amended as it's specified, and then the question number two is also approved, we have two kind of conflicting things in our charter, would we not?
Chair and members, I don't agree with that. If the first question is saying, should the voters get to decide? Or should the voters get to vote, rather? Should the voters get to vote on this issue? And then the second question is the voters voting on the issue. And so if you had a yes vote to the first question, that the result of that would be that language would appear in our charter. And then we would include some language that would say, the voters voted on this in November 3rd, 2020, and they voted to XYZ. And so if question one passes, then that language will appear in the charter. If question one passes, however, we will also have to potentially readopt any language that we need to have in place in order to have garbage picked up because of the effect of that second sentence in that charter amendment.
So if both pass, they would both be in the charter, right?
Correct.
And yet, with the question one being affirmative, all of those ordinances would then be nullified, correct?
Correct.
And we would have no authority to continue organized collection. Is that right?
Correct. We would have no authority, and we would also have no rules about garbage collection. As collection, we have other rules about garbage, solid waste collection, and we would need to analyze, and we actually have already started that analysis about what would need to be readopted in order to just not have garbage in the streets.
So why would we set up that possibility?
The outcome of that Jennison decision in February was that this charter amendment needs to be voted on by the voters, and so we don't have the ability to. We can't make that second sentence go away. The court said that it's valid, so it's there.
I understand that, but why wouldn't the second question be in the affirmative and in some way provide for continuing to elect as we do now? I guess I'm and now that I'm thinking this through a little bit, it really doesn't seem like that really the second question doesn't really solve anything from a perspective of if question number one is approved. I don't get it. Why do we need a definitive sentence that says we can't do it when the first one says it was already approved and it says we can do it? We just have to get the voters to approve it. I am now at a position where I don't see the point of question two. What is your intent in offering the voters the second question?
Chair and members, the first charter amendment is talking about should the voters be allowed to vote on it, and in the replacement of the competitive marketplace with organized collection. Well, that's already happened. The city has already replaced the competitive marketplace with a system of organized collection. And we've amended the ordinances, we've entered into contracts, all of that has already happened. So we believe a second question is necessary and actually called for by this petition. This petition is saying you have to go to the voters to figure out whether you can have organized collection.
Okay.
That first question in our minds, and minds can differ, but in our minds does not lead to, yes, we're going to have organized collection, or no, we're not. One of the folks that testified during the public hearing commented that that first question still allows for a system to be in place and mentioned municipal collection. I don't know that that it's a reasonable that all voters would find it to be a reasonable outcome of voting yes on question one to be that the city starts collecting their garbage with, creates a garbage collection, buys all these trucks and starts a municipal collection process. So we believe that that we need a definitive question about whether the city can contract with independent haulers to create an organized collection system of collecting solid waste in the city, because we don't believe that that first question gets us there.
So again, why wouldn't you put your question two in the affirmative?
Commissioner Barnes, perhaps I'm not understanding what you mean by putting it in the affirmative. Do you mean?
Well, both of our choices of approving or rejecting the charter amendment says the council shall not enter into a contract. Why wouldn't you say the council is authorized to enter a contract?
Chair and members, we certainly could have that be the amendment. As I discussed earlier, that I believe that that this was the better route to go to draft it the way that it's presented before you. There's certainly, more than one opinion on that. I've discussed the reasons that I think it needs to be written this way, or that it's actually more clear written this way. But I can appreciate that there's multiple sides to it. We've debated all of this at length internally. So I appreciate it, and I have thought through what I think is potentially in your mind as well about this.
Thank you, Commissioner.
Okay. Well,
thank you. There'll be further discussion here, and maybe that'll bring some clarification. Commissioner Peterson, you have your hand up also.
Thank you, Mr. Chair. So I think the previous discussion kind of illustrates, I think, one of the fundamental questions that we have to ask here, which is, I think is whether, and that was, I think, the question that was being asked by the previous speaker around whether the question that we're being asked about ought to be kind of set in the negative, as is proposed by the city council, or whether it should be set in the positive. And the rationale that the city attorney and the council are putting forward is that is kind of a simplicity in communications argument around the charter, which is that if you want the city to get out of the trash business, you vote yes for both charter amendments. If you want the city to stay in the trash business and you like what the city is doing, you vote no on both of the amendments. And I think the idea that the city attorney and the council are trying to put across here is that from a voter communication perspective, getting a postcard that says, "Hey, here's the issue, and if you support our particular position, you should vote yes for both things, or you should vote no for both things." It's easy to communicate, but the result of that easy to communicate around the kind of bullets that you ought to fill in is this complicated sounding wording that is being described here. And so I think the choice for us, I think, is if we accept the advice of the city attorney that, and I do accept it, that we need some form of charter amendment in order to clarify the intention of what's being asked here and make a definitive decision so that after the election this fall, we know for certain kind of what the intent of the voters is. We've got two choices. One is we can make it easy for people to say, just vote yes, yes, or vote no, no, and have a particular outcome. Or we can have something where communications have to say, you have to vote yes for the first thing and no for the second thing, if you want one outcome. You have to vote no for the first thing and yes for the second thing if you want the opposite outcome. And that's really the choice that we have before us if we take the advice of the attorney that we need to act in some way.
Thank you, Commissioner Peterson. Commissioner Weatherby, you have your hand up?
Yeah, what I was wondering is if you're going to do this summary voter that tries to make it very simple, what Steve was saying is if you do yes on both, no on both, but could you just have the same statement over each, what am I trying to say, ballot question? So if you say on the first ballot question, if you vote yes to this, then we will end organized collection. And then on the second one, you say, if you vote yes to this, you will be voting for organized collection organ. I'm totally confusing that up. Okay, so the first question you would just read it and say, yeah, do you see what I mean? You'd have exactly the same language. So the voter knows that they're voting yes for this. They also need to vote yes for this. Does that make sense?
Yeah. Chair, Commissioners, we actually, pending the outcome of your action tonight or at a later, we plan to talk to the county about whether it's possible to put that language, if you vote yes, it means, in the question. Because that kind of approach is taken by levy raises, where it says, if you vote yes, you are voting to raise your levy by X number of dollars or, whatever it is. And we think that is a clarifying way to go. That said, there are limits to what, the ballot approvers are comfortable with. Well, not approvers, but the ballot formatters. We have limits. We have the header, the title can be 10 words. And the question has to be answered in a yes or a no. So we have some limits in state law and in the rules about what we can put in these questions. But we plan to ask whether we can, whether it would be advisable or prohibited from where they put some sort of yes, if you vote yes, it means kind of language in the question, in that second question.
And Melissa, when would you expect a response from the county on that? I'm just curious.
Well, Chair and Commissioners, they don't have to. We asked about questions and can answer all sorts of things. Sometimes they'll find that it's not a technical question and that it's asking for a legal opinion, and they'll defer that question. So we can ask. One of the challenges is that this particular method of amending the charter is just, and so there aren't very many examples for us to look at, or for us, other charter commission attorneys to call and talk through about, sort of what was the voters' experience. Its method just is very rarely used. So a lot of good examples out there, and there's not a lot of explanation of the voter experience. But to the point of clarity, we would work very hard to make it clear for the voters.
Thank you. Commissioner Extell.
I thought Commissioner Peterson said it very eloquently in that yes, yes means this, no, no means this. And I'm confident with the guidance we're getting from the city attorney to move forward with the question we have this evening. And I'm also confident that once this is behind us and the ball starts rolling, is that both parties to the issue will do a tremendous job of communication to our constituents. Given the fact that this is a presidential year election, I think that we'll have strong voter turnout, and the end result will be a decision, I think, made by a vast majority of the voters one way or the other. So, with that said, I certainly approve going forward yet this evening and approving this, rather than spending another hour and a half debating the same language.
Thank you. I want to pass through. We've got two additional hands up. Commissioner Stanley. Commissioner Stanley?
There we go. Sorry. Irrespective of my earlier comments, I'm not opposed to the language of the charter amendment itself, because it's just language of a charter amendment that we don't even know we're going to have to put in, depending upon the votes. But my problem is, this yes, yes, no, no vote that was alluded to here several times. It doesn't guarantee that someone's not going to vote yes, no, or no, yes, or in some way vote. And I say this only not because I don't have confidence in the ability of the city attorney's ability to draft something that can't possibly conflict, but I'm uncomfortable with it. And as long as the public is asked to vote on two different things that could potentially lead to a confusing outcome, well, then we're back in court again. And I would feel better myself if I'm going to vote for a change in charter language. I would feel more comfortable waiting to make that vote after I see what the language of the second question itself would be, so that we can better understand the logic of how we get to that amended language.
Thank you. And finally, Commissioner Barnes, you have your hand up.
I do. First of all, I think I finally got the need for a negative position, and I believe it's correct. You can correct me if this characterization isn't correct. The first question contains the sentence unless first approved by a majority of the voters. And what you're actually trying to accomplish with the second question is to have that vote taken place. Is that not correct?
That's exactly.
And I know you've said that several times. It just didn't go in. So
Complicated. It's very complicated.
So I'm with that. I think I'm ready to approve the position that the council has sent over.
So that's a motion?
That we, I suppose I should use the.
Probably should read it from the, yeah, exactly.
So a resolution, let's see, Charter Commission resolution, it'd be 20 something C, I guess. I would move that we approve the Charter Commission. The Charter Commission approves the City Council Ordinance 2020-11 as attached in Exhibit A, and direct the attorney to inform the City Council of the same, such that the ballot language can be set for the November 2020 general election.
I'll second it. It's Brana.
Thank you. We have a motion and a second. Any further discussion regarding the motion and the second? If not, we will call vote.
Thank you very much. Axel?
Mr. Chair?
Yes.
Mr. Chair?
Yes.
Can you clarify the motion again, please?
Chair, I'm happy. This is the city attorney. I'm happy to clarify the motion.
Thank you.
I believe it was a motion made by Commissioner Barnes, seconded by Commissioner Lindell, to adopt resolution number 2020 it'll be 1C, approving the proposed amendment to the city charter as set forth in ordinance 2020-11. That was the ordinance that was adopted by the city council on April 20th. And then further directing the city attorney to notify the city council of the action at the charter commission this evening. Is that accurate, Commissioner Barnes and Lindell?
Commissioner Barnes, is that accurate?
Yes, I'm sorry, I had my mute. I agree.
All right, we will now proceed with the roll call vote on this.
Just a reminder to remove the mute on your phones or on your systems to vote.
All right. Axel?
Aye.
Beloga? Jack Beloga, can you hear me?
Can you hear me?
Yep, there you are.
Okay, I abstain.
Barnes?
Aye.
Vermont?
Negative.
Gustafson?
Negative.
Hunt?
Aye.
Lindell? Nelson?
No.
Grant Peterson?
No.
Keith Peterson?
Aye.
Stanley?
No.
Taylor? Thorson?
Aye.
And Weatherby?
No.
I'm sorry, Commissioner Weatherby, I didn't hear your vote.
I voted no.
Okay, thank you.
And Denise, what is our tally?
We have voting against, 1 abstention, and, sorry, not math here. 7 voted in favor. And 6-1.
And this item just requires a majority vote. Is that correct, Melissa?
Chair and members, I am just double checking the rules. I believe it's a majority vote, but I'm just double checking. I don't find anything, Chair, in the rules that would suggest that anything other than a majority is necessary.
All right. With that opinion, the motion passes. Melissa, there's been some discussion of the wording and concerns over what might ultimately appear on the ballot. Is there an opportunity then for the Charter Commission to provide feedback as this moves forward on the exact wording?
Chair and members, I would welcome any feedback, as always. And I think it would be helpful for all those involved. And because of the request tonight, I will be proceeding to prepare some ballot question language and in moving that process forward. So I think it would be helpful for me to share that. And I welcome any feedback that you have on the content of that drafting, as far as clarity, understandability, as well as any additional discussion you might want to have to talk through this. I'm always happy to talk with folks, and you're certainly welcome to contact me about that.
Thank you. And I assume, though, your openness to hear people's views applies to the general public as well, that might have some feedback on that area.
Chair and members, the general public periodically provides feedback, and I think it's helpful for them to provide that, and it all depends on who they want it to be provided to. Sometimes they send it directly to me, and sometimes they send it to their representatives on these bodies.
Thank you. All right, moving on to item 6, hearings and resolutions. I guess we just had our hearing. Is there anything else in for item 6?
Chair, I do not believe there is.
Item 7, communications. Is there anything?
Chair, this is Melissa. I do not believe that there is, other than just again a reminder that the contents that was submitted by email and telephone to for public comment and on any item on the agenda, perhaps, was prepared and sent out to you in advance of this meeting tonight.
And they are a part of the public record, correct?
Commissioner, Chair and Commissioners, they will be also added to the public record in addition to the PowerPoint slides.
Thank you. Moving on then to item 8.1, the choice voting update. So this is not going to be a public hearing tonight. This is just an update on the process. And so there's not a public hearing associated with this either. So with that, let's hear the update.
Thank you, Chair and members. I think it's helpful for you to be kept in the loop whenever there is activity related to charter amendments. Would it be possible to mute the lines? I'm getting a lot of feedback, and I wonder if others might be as well and having difficult time hearing. Sorry about that. So I thought it would be helpful for you all to get an update from me and have an opportunity to ask some questions so that you were in the loop on what the City Council had directed staff to work on. There has been some discussion about ranked choice voting, and we had a concurrent presentation before the Charter Commission and the City Council last year about the topic. Some of you were probably there for that. The topic has been out there for a while, and recently the city council directed staff to prepare an ordinance that would amend the charter if adopted by the voters in an election. So it's again using the process that we've talked about tonight. The consideration of that ordinance before the city council will be on May 18th. So in a couple of Mondays from now. The materials were posted on the city's website today. So the ordinance if the city council adopts that ordinance on May 18th, we would ask the Charter Commission to meet on June 11th to discuss, hold a public hearing, and again, take an action similar, or to have a discussion and potentially take an action approving, rejecting, or offering substitute amendment, similar to the discussion you had this evening. And the soonest that we believe that that could happen is June 11th, so that we can properly advertise a public hearing on the matter before the Charter Commission. Again, it follows that same statutory process that I discussed tonight. That draft ordinance, as I mentioned, is on the website, as well as some FAQs, some frequently asked questions. We believe as this item goes out that there might be a desire for some additional information about what this means for those folks that probably don't recall the discussion about it back earlier in the year. So when we get to that stage, we'll have some more information out there. And I put some additional sort of timelines here on this slide. The asterisks are making an assumption that if the action is acted on by the Charter Commission on June 11th and on June 11th it approves that City Council ordinance language, then the Council and Charter Commission process is laid out there as just a general guide for you. Again, the same 60 and 90-day time periods are available in state law, as the same as for that solid waste collection question we talked about tonight. It's just starting later in the process than the solid waste question. So I just wanted to give you all an update about the possibility of that coming to you at a June 11th meeting, and stay and be available for any questions that you might have on that topic tonight.
Thank you. I appreciate the update. Commissioner Hunt, I apologize. I think your hand might have been up for a while. I don't know if I missed it related to the other item, but I will call on you now, whether it's this item or you had something else to say.
I did not, but thank you for asking. I had not taken the hand down, but I will ask the city attorney. So basically, it's if the council decides they want to pursue this on May 18th, up or down is their decision to pursue, then brings it back to the Charter Commission.
Correct. Chair and Commissioners, the method that the Council has directed staff to proceed down is the same method to amend the charter as what we're using for that question 2 of the solid waste that we discussed earlier tonight. And that is that potentially the voters would be asked in an election to amend the charter. So for example, the ballot question, again, now all this is hypothetical, but the question would be something along the lines of, should the charter be amended to use ranked choice voting to elect the mayor and city council members? It would be something along those lines. But the ordinance that the council is going to look at on May 18th is going to be the actual charter amendment, like you all had before you tonight. It's the actual language that amends the charter that would make ranked choice voting possible. Under our current charter, it's not possible.
Thank you. Commissioner Barnes, you have your hand up.
Yes, sir. Thank you. Because of the late time, I'm not going to belabor the issue here, but I do want to say that I am in favor of ranked choice voting, and I've studied it quite a bit. I'd like to send out my analysis of why I think it's appropriate to all of the commission.
Point of order, Mr. Chair. Point of order.
Yes,
This is an update. It's not a time for discussion.
correct. So yes, this is just an update. So if your questions are about the process, that's appropriate. If your questions are about, the item itself, there'll be an appropriate time to discuss that.
So the process is the question. Is it allowed for me to distribute this information? And if so, how do I do it?
You would send it to the council secretary, the secretary. We have to be wary of open meeting laws. And so if anybody has anything they need to share with anyone else, it should go to Denise, who will then distribute it. You should not email it to us individually.
All right. Thank you.
Seeing no hands up, I will move on to the next item. Explanation of city email account requirement. And this touches a little bit perhaps on my last comment on this item and the importance of that.
Chair and members.
Yes, I believe you have the floor on this one also.
Yes, this is the Melissa Manderscheid show. I'm sorry I'm talking so much. All right, so I'm happy to report that 13 of the commission members have signed up and filled out the necessary paperwork to have a city email account. And I want to just talk to you a little bit about why we need you to do that. And I want to reassure you that I appreciate that it is another email account to check, and that is another administrative task for you to do. However, I want to underscore the need for it. You can, and also mention that you can set up notifications in your accounts to let you know when you've received a new email. Plus Denise says, you can sign up for e-subscribe to know when the packets go out. And there's all kinds of checks in place that you can make sure that you're checking the email when you need to. But in any case, it's important that we have city email accounts for a couple of reasons. One, it's a consistent communication method. In some cases, people are using or have used work accounts, and those work accounts oftentimes have filters or blocks on them, or they limit attachments. And so the danger is that commissioners might not be getting all of the information that's coming and missing things. And so by having a city supplied email address, you'll get everything, it'll all get delivered, and you'll be able to open the documents. And if you're not able to open them, you'll be able to use the support of our IT department to assist you in doing that. The other point, the other value in using it is that it's an official communication form. So if someone wants to communicate with you, you'll have that email address to use as opposed to giving them your Gmail account or what have you. And then potentially opening up your private email account to being bombarded with emails about, whatever the topic is. Another important part about using it is that it prevents, and I think this is very important as somebody who deals with litigation on a regular basis. If you're using a city email account, it prevents you from having to provide your personal device or your personal email accounts in the event you have a data request that you have to respond to, or there is a litigation hold placed on your account based on litigation, the beginning of litigation. So there was a data request that came in very recently, and it's going to require you all to do some searching through your email accounts and other communication devices that you have. And if you have a city email account and you use that for all of your city related communications, which is what we're asking you to do, it will be much easier for you to respond and organize your official communications in one account as opposed to having it in a private account. And then lastly, and it's very important also for our records retention obligations under state law and data practices, if you email account for your city communication, once you are no longer a member of a commission, we will still be able to access those messages so that we can still provide a response, a thorough and full response to requests for data, or if we're looking for something sent or received using the city's email address. So although we appreciate, and I fully do, I have multiple email accounts I have to check each day. I fully appreciate the sort of additional burden this places on you, but I can tell you it far outweighs the burden you will have in responding to a data request or producing your personal cell phone, because that's where you have your city emails, your commission emails on your email account. So it is out of my desire to protect from that unfortunate experience that I want to really underscore and drive home my request that you use the city email account for all of your city related, commission related communications. It will make it easier for you on the back end and a little bit of a burden on the very beginning of it. So thank you to those 13 that have already signed up and have undertaken that process. And I believe that there's just a couple more of you that need to work with Denise and IT to make that happen. And I'll just stand for any questions that folks might have.
Melissa, this is Chair Thorson. What do you recommend we do in a case where somebody already has our email address because they know us through other channels, or we serve on a board with them, a nonprofit, whatever it might be? I myself, Chamber of Commerce member, my personal email is published. How do you recommend that we channel, or do you recommend that we, regardless of how a question or a comment or a concern regarding Charter Commission business is sent to us, are you recommending that we respond to that? We can't stop it from coming to us, but we respond to it then from our city email address to keep things clean, so to speak?
Chair and members, what I would do if that happened to me is that I would forward that email from my private email address to my city account, and then respond to the sender, the original sender, from my city account. So then it would prompt them to have a new email address and use that in the future. I would also encourage you to say something like, please use this email address for future communications with me. You want to forward that email to your account, your city account, so that it lives there and the permanent record of it is there, as opposed to having it on having the only place that it lives on your Gmail account or what have you.
Thank you. Commissioners, questions, comments, concerns? Well, again, thank you to everyone who has established their account. And I know that for myself, it can be a challenge to remember to, do one more account here. Commissioner Stanley.
Commissioner Stanley, you have to turn your mute off.
You're muted, Commissioner Stanley.
Every time. Question for perhaps Denise. On the city's website, where the commissions are all listed and the commissioners are listed, are our city email addresses published there? I don't recall.
No, they will not be posted on the city website. They will be public information for anyone that asks, but we are choosing not to post the individual email addresses on the city website and encourage the liaisons to kind of field the questions on behalf of an entire commission.
Okay, then as you know, Denise, I got 4 or 5 emails from people over the last few days related to tonight's topics, most of them on organized collection, one of them on ranked choice voting. They all came to my city email address, which I forwarded to you just for response purposes and because I really didn't know how to handle it. And I was curious as to how they got that city email address.
Sure. So anyone that has already filled out the authorization form, signed it and sent it back to IT, your email addresses have been updated with the city email addresses. And then those of you who have not done that yet, your personal email addresses are still being used. And so that's the information that is public now.
So these people that emailed me presumably then contacted someone at the city for this information?
I did get a couple of requests for all of the Charter Commission members' email addresses and phone numbers.
Okay, thank you.
Any other questions of staff? All right, thank you again, Melissa, for your update on this item. Moving along to item 8.3, approving the draft report. Those of you who have been on the commission for a while understand that we're approving a report. I don't know how to explain. We're approving a report that's sort of a fill in the blanks, so to speak, as to the action we took this meeting. Actually, shouldn't this be at the very end after election of officers, or does it matter?
Chair and members, I concur that this would be a little premature at this point in the agenda.
Correct. Okay.
Yeah, so we can move this.
That's typically the last item we do before adjournment. So we will move it.
I'm sorry to interrupt. I will say that per the rules of procedure, it's laid out, and this is where it falls in the agenda. Another one of those things that we'd love to see changed, but as the agenda sits.
Okay. I didn't realize that because we usually also, don't we indicate the election of officers in that draft report?
Mm-hmm. Yes.
So, all right.
But Chair, you can make a motion to move it to 10.2.
All right. So I would make that motion to move that item to 10.2. Do we have a second?
Second.
And who made the second?
Byron.
Okay, thank you. And again, we'll do a roll call vote for the record.
Thank you very much. And for the record, I would like to say that Axel has left the meeting, so he will not be voting. Beloga?
Aye. Aye.
Barnes?
Aye.
Gutermont?
Aye.
Gibson?
Aye.
Hunt?
Aye.
Liddell?
Aye.
Nelson?
Aye, and signing off.
Grant Peterson?
Aye.
Grant Peterson?
Aye.
Thank you. Steve Peterson?
Aye.
Stanley?
Aye.
Taylor?
Aye.
Thorson?
Aye.
And Weatherby?
Aye.
All right, motion passes unanimously. We're on to item 9, election of officers and appointments. The first item is the election of a chairperson. Do we have any nominations for chair?
I nominate Mark Thorson as chairperson.
And second.
Are there any further nominations?
Who was the
Not,
second
we
on that?
will.
Is it possible to nominate for all 4 positions and then take one vote?
We're going to do a nomination for vice chair Then we will do recording secretary and city attorney or attorney separately. We can take these two together. So I'm looking for motions for a vice chairperson, nominations for the vice chair.
I'll nominate Carrie Weatherby, Vice Chair.
Stanley, thank you. Any further nominations? Any further nominations? If not, we will take the slate, which would be to Thorson as chair, Weatherby as vice chair, and we will now do a roll call vote on this item.
Thank you very much. Loga?
Aye.
Barnes?
Aye.
Gudermont?
Aye.
Gustafson?
Aye.
Hunt?
Aye.
Lindell?
Aye.
And did Nelson, did he say he was signing off?
No, aye for now.
Oh, okay.
Thank you.
Nelson, thank you. Grant Peterson?
Aye.
Steve Peterson?
Aye.
Stanley?
Aye.
Aye.
Thorson?
Aye.
And Weatherby?
Aye.
All right, thank you, everyone. We will move on to item 9.3, appoint a recording secretary. Do we have any nominations for recording secretary?
I nominate Denise.
I'll second that.
We have a motion and a second. Any further nominations? If not, we will proceed to a roll call vote.
May I first ask who made that motion?
Barnes.
Thank you. All right, Beloga? Barnes? Gudermont?
Aye.
Gustafson?
Aye.
Hunt?
Aye.
Lindell?
Aye.
Nelson? Nelson, they have signed off?
I believe he signed off.
Okay, thank you. Grant Peterson?
Aye.
Steve Peterson?
Aye.
Stanley?
Aye.
Taylor?
Aye.
Thorson?
Aye. Motion passes.
Oh, wait.
Motion again passes. Motion again passes unanimously. Item 9.4, appoint.
Sorry, I'm gonna interrupt you one more time. I didn't hear your vote and I didn't get Weatherby's.
Okay. You didn't hear my vote? I was an aye.
Okay, thank you. And Weatherby.
Aye.
Thank you very much. Sorry about that.
All right, now the motion passes unanimously, and we're moving on to the item for appointing the attorney for the Charter Commission. Do we have a nomination?
So moved.
You have a person to nominate?
It was so moved for Melissa.
Manderscheid.
There you go. I'll second it.
Thank you. All right, we have a motion, a second. Any further nominations? If not, we'll proceed to a roll call vote. Denise, you're muted.
How'd that happen? Beloga? Barnes?
Aye.
Gudermont?
Aye.
Gustafson?
Aye.
Hunt?
Aye.
Lindell?
Aye.
Grant Peterson?
Aye.
Steve Peterson?
Aye.
Stanley?
Aye.
Taylor?
Aye.
Thorson?
Aye.
Weatherby?
Aye.
And with that, again, motion passes unanimously. Thank you, everyone, for that. And we'll move on to item 10.1, and that is setting the date for the next Charter Commission meeting. Melissa, is this one in your court?
Well, Chair and members, sort of like Denise and mine, I guess. We have Denise, I don't know if you sent out a doodle poll or not, but June 11th is the date that we're hoping to have the next meeting. or it's a reservation of the date in the event we need another meeting. So I would ask for a motion to set that as the next date.
So moved.
Stanley.
Taylor.
Motion was by who?
Jay Taylor.
And who seconded?
Like,
All right, motion and a second. Again, roll call vote. I apologize for these, but it's a way to.
It's required by the law.
I'm sorry, I didn't get who seconded that. Was that Commissioner Stanley?
Yes.
Thank you.
Mr. Chair,
Yes.
point of clarification that June 11th reservation is contingent upon the city council action of May 18th.
Good point. Thank you. All right, on to our roll call vote, please.
Thank you. Beloga?
Aye.
Gutermont?
Aye.
Simpson?
Aye.
Hunt?
Aye.
Dell? Grant Peterson?
Aye.
Steve Peterson?
Aye.
Stanley?
Aye.
Taylor?
Aye.
Thorson?
Aye.
And Weatherby?
Aye.
All right, item 10.2, this is the approving of the draft report.
I move that we approve the draft report.
Second. Taylor.
Motion and a second. Again, roll call vote.
Beloga? Barnes?
Aye.
Gutermont?
Aye.
Simpson?
Aye.
Hunt?
Aye.
Lindell? Ronna Lindell?
Yep, I couldn't hear you. You're fixed now.
Oh, all right. Grant Peterson?
Aye.
Steve Peterson?
Aye.
Aye.
Taylor?
Aye.
Thorson?
Aye.
And Weatherby?
Aye.
All right, who gets the honor of making a motion to adjourn tonight's meeting?
Oh, Jay Taylor.
Everybody's moving, yes.
Motion by Taylor. Was that a second, Stanley?
Sure, yeah.
Oh, you,
Does this also require a roll call vote? I guess it does. We have a motion and a second. We'll now carry a vote to adjourn the meeting.
All right, drum roll, please.
Yes.
I heard Beloga's aye. Barnes?
Aye.
Ronald Barnes?
I said aye.
Oh, thank you. Gutermont?
Aye.
Hunt?
Aye.
Gustafson?
aye.
Lindell?
Yes.
Grant Peterson?
Aye.
Steve Peterson?
Aye.
Stanley?
Aye.
Taylor?
Aye.
Thorson?
Aye.
And Weatherby?
Aye.
Meeting is adjourned. Thank you, everybody, for your patience and contributions. This has been probably one of our longest meetings ever, so I appreciate everybody's involvement.
Good job.
Thank you.
Thank you.
Thank you. Stay safe, stay
And
healthy.
at 10 o'clock, right on the button.
Bye, everyone.
Bye-bye.
To leave the meeting, you'll click the red X circle on the bottom.